Okay, hello, Your Health Can't Wait Freedom Insiders. I'm with Josh DeHaas, counsel at the CCF. I am, of course, Joanna Barron, executive director of the CCF. And we just thought that we would record this video, first of all, to thank you for your support over the years. This case fighting for healthcare choice and healthcare freedom in Canada has been going on for about a decade, and many of you have been supporting us from the beginning. And the fight isn't over. So we wanted to give you first a bit of an update on the latest litigation matter over the costs of the Candy matter. And then Josh will talk about what is next in terms of the legal fight for healthcare choice. So as many of you know, on July 18th and 19th, we were in court in the BC Supreme Court over the matter of costs. The Attorney General of BC is seeking $1.7 million in legal costs, which would be a crushing amount. And of course, this is funds of taxpayer money that they spent fighting against your right to take your health into your own hands. And just for perspective, the CCF, our whole operating budget for a year is $2.1 million. So this would be a crushing cost award for us, but that's not really the point. I wanted to tell you a bit about what actually happened at the hearing because it wasn't broadcast on Zoom or anything like that. So the question when a judge is to determine whether he or she should exercise the discretion not to award costs, even where the claimant has been unsuccessful. So here the Attorney General was successful at the appellate stage. And as you'll remember, the Supreme Court of Canada very unfortunately declined to grant leave in the matter, even though, as many of you still have told me in the last few days, there is this glaring inconsistency in that Shauli is still good law in Quebec. So in Quebec, you effectively do have a constitutionally recognized right to take your health into your own hands. And in the rest of Canada, you don't have that same right. So there's an obvious inconsistency, but the Supreme Court denied leave. In any event, there's a few established factors that a judge has to look at when deciding whether to exercise their discretion not to award costs, conduct of the parties, the novelty or complexity of the legal issue, whether the litigation is in the public interest and financial circumstances. And the Attorney General really focused on the conduct of Candy, of us, Dr. Brian Day, as well as the patient plaintiffs. And they made a pretty, to me, because I've been following and working on this case since I joined the CCF in 2016, they alleged that we had been dragging out the litigation matter when quite the opposite is true. The Attorney General brought many unnecessary evidentiary motions and procedural motions, and it was very clear to all involved, including the judge, that the strategy was to effectively bleed us dry because they have an unlimited pocketbook, and we were, a small litigant. So we even had to recess the proceedings for a period to raise more money because we were going to run out of money, of funds. But in any event, so that was really their focus. And also, very notably, the Attorney General completely ignored the decision of the Court of Appeal. And the Court of Appeal decision is important because it, first of all, recommended against ordering costs. And it also, at many points, emphasized that the nature of the litigation seeking to declare the constitutionality or unconstitutionality of the BC Medicare Protection Act provisions, which effectively prohibit private health insurance, the Court of Appeal, even though it declined to allow the appeal from the trial court decision, it did make clear that it was public interest litigation, that this question was in the public interest of British Columbians to be resolved. It also found numerous errors with the trial judge. And finally, and most importantly, it declined to impose costs. And at the end of the hearing, the judge in the cost matter asked the Attorney General's counsel what its position was in relation to the Court of Appeal decision, because that had been the emphasis of our submissions. And the counsel for the government, quite shockingly, said that the Court of Appeal decision was to be ignored entirely, and the trial result was all that mattered for the determination of costs. And we understand from our lawyer, Jeff Cowper in Vancouver, that the reaction of the judge was, very puzzled, didn't take it very well. And so we're hopeful as to the outcome. We expect the decision will be at least some months for us to get, but that is the update on the cost matter. And many of you donated to help us pay our legal bills in that important matter, and we thank you for that. But whatever happens with that decision, the fight for healthcare freedom is not over. And so I'll turn it over to you, Josh, to give an update.
Sure. So yeah, so we're a little bit optimistic after the cost hearing that we won't get hit with the full 1.7 million. We're also optimistic that this fight is not over. So Joanna mentioned the Chowley decision, which is a 2005 decision where a patient who needed a surgery and was suffering painfully on a wait list found a doctor who was willing to repair him, but because of Quebec's arbitrary laws, that was not allowed. And he took this all the way to the Supreme Court, where there was a really interesting decision. I sort of have to get into the weeds of that a little bit here to explain where we're going next with our litigation potentially. But basically in that decision, there were 7 judges. 3 of the judges agreed with our position, which we also took in Canby, that when the government puts in place laws that are arbitrary, that prevent you from taking your care into your own hands and lead to suffering, or in some cases, even death, because people are dying on these waiting lists, something that the BC Court of Appeal acknowledged, that violates your right under Section 7 of the Charter to life, liberty, and security of the person. The life part being obvious, if you die on a waiting list, and the security of the person part being your bodily integrity being seriously harmed by being forced to stay on this waiting list by these laws. So, like I said, 3 judges agreed with us that Section 7 is violated. 3 judges in dissent said that it was not. And a 7th judge, she said that she wasn't sure if Section 7 was violated or not, but the equivalent under Quebec's charter was violated. That's called inviolability. And so it's unconstitutional in Quebec, but apparently still constitutional to do in British Columbia. And like we said, the Supreme Court, much to the shock of pretty much every legal observer, decided not to take that up. So the 3 judges in dissent, one of the reasons that they said that these laws are constitutional is the fact that provinces have what they called a release valve. And these are programs that a lot of people don't know about. I didn't know about them before I came to the CCF. But essentially, they said the reason that Quebec can do this, that provinces can limit your rights in this way, is because they'll always send you abroad for your surgery if you really need it to avoid suffering. And Quebec has this program, British Columbia has one, Ontario has one too. They're all slightly different, but I've been digging into this program a lot, talking to a lot of patients who are trying to make use of this program. And in Ontario, it's called Section 28.4. So, sorry, Regulations 28.4. And the Ontario program, basically, you can apply for to get your surgery or your treatment in the United States. If it's not available in Ontario, you apply ahead of time. It's not something experimental. It's something that's considered, the best practice here in Ontario. And you need it to avoid either death or irreversible tissue damage. And the way that the province often gets off paying is they say, well, yes, you suffered tissue damage. Yes, things got much worse for you, but we can fix that eventually if you just stay on the waiting list. And so we don't think that's good enough. We think that this is not the safety valve that the dissent was talking about in Chowley. And so that's one area of attack. And we're looking for patients to say, this is not good enough. The right is the right to security of the person and to life, and your laws are arbitrary. They're therefore violating the Constitution. So the long story short, we're going to continue to fight. There's still lots of ways we can challenge this despite the Supreme Court shutting us down in British Columbia. And yeah, I just want to also say thank you for all your support.
So thank you. We'll be keeping in touch, and we hope that you keep in touch with us. If you hear about people who have been affected and have tried to benefit from these release valve provisions and have been given the runaround, we very seriously want to hear from them. And thank you again for your support, and we'll speak to you soon. Bye.